Welcome to my recap. I know I did one of these on Monday, and it's only Friday, and there's still testimony today, but I'm supposed to be doing Friday recaps. There's not supposed to be testimony on Fridays. They're supposed to work Monday through Thursday. It's just not happening. The trial that refuses to end continues. So, this week was just absolutely explosive, but not in front of the jury, of course. The Monday, I did a recap for you. They came in the afternoon. They only did about 2 hours of work. Adrien Bean was still on the stand. He didn't really see anything valuable. I can't remember if it was Monday that he said he was high, so he was sleepy. But one day he did testify that he was high and therefore sleepy. I can't remember if it was last week where Adrien Bean popped off about his phone number being released, or if that was on Monday. But I mean, I think it was last week, he went on a tirade. He was, his phone number had been released to the public. They were playing one of the videos that had his phone number. And of course his life is being threatened and all kinds of stuff is going on. Okay, so Monday, they get a little bit of testimony from Adrien Bean. It's not even really worth going over because he doesn't remember anything. It's so so annoying. Oh, okay, so it's on Tuesday that Adrien Bean returns, and he says that he is high. It's like, why are you admitting to a crime while you're on the stand? Like, what kind of... Also, he's like too high to pay attention. He said he's falling asleep. I'm sure this is quite boring for him, there's no doubt. But you could be falling asleep without being high. I kind of love Mr. Adrien No Man Bean. I mean, goodness gracious. The guy he's wild. He's just wild. Okay. So he's cross-examined by Steele, and then I think the guy's name is Max. I can never hear. Oh, by the way. Oh, actually, let me get into something somewhat interesting. Okay. Miss Love after the cross-examination of Bean, Miss Love does a redirect where she asks, and in her questions alludes to Attorney Steele, YSL Steele, breaking rules or laws. She does this in front of the jury. She kind of asks about facts that are not in evidence. All the defense counsels objected to it, and the judge overruled every single objection. So here we have Ponytail, who represents this guy, whose name I don't recall. But he is about to present a motion to separate his client's trial. And so here we go. Let's see if we can hear him.
I think that the current cross-examination suggesting that counsel is putting facts before the jury that don't have any foundation, or to confuse them, or...
Hold on. Does he have a hand tattoo? Is that a tattoo on his hand?
Or through an investigation.
It is. Oh, he's a gangster. Okay, the ponytail means something now. Okay, interesting.
That aren't exactly facts that are and can be established as prosecutorial misconduct. I'd refer to specifically, for example, with those examples, with regard to confusing the jury, with regard to someone's investigator, United States versus Rios are...
Hey, Doug's suit looks nice on this day. He's wearing a maroon suit. Just
IOS 611 Fed Second 1335. At 1342, that's a 10th Circuit case from 1979. I am not talking about the quantum of proof. I am for the spillover effect. But the nature of the attacks on co-counsel and lack of any connection of any of this evidence for the last, how many days has Mr. Bean been on the stand? How many trial days?
5.
None of
6,
which
forever.
has any specific connection to Mr. Nichols whatsoever. So, based upon what I believe is now personal attacks between lawyers, and nothing to do with Mr. Nichols, the spillover
Okay, I guess
effect
that his client
has
is
now
Mr.
reached
Nichols'
a
guy.
point where I believe we are entitled to a severance and/or my favorite and your favorite, the 105 instruction.
I don't
Yes,
know
sir.
what a 105 instruction
Okay,
is
Ms. Love,
because I'm
Ms.
not in
Hilton.
Georgia. Obviously, Ms. Love objects, will make noise to me. Mr. Bean continues to carry on, and then our guy.
On Friday,
Also, sorry, timeout. Did you see that awful green pantsuit? Like, why are you wearing that bright green pant? Look at what I just. Okay, so I can't tell if this guy's name is Max Sharp or Mac Sharp or Mac something. I don't know, but he's a good lawyer.
March 4th, you testified that someone threatened to lock you up if you didn't come to court.
I had answered that question though.
Okay, well, I want to ask you that question. I want to ask you a follow-up question. So, who threatened you?
I had answered that already. Then nobody threatened me. It's just a subpoena that went out like I answered that question.
So,
And
no,
if you don't answer to that subpoena, then
Okay, here he is, Max Sharp or
the
whatever. his name is.
indictment in evidence that shows your name and Mr. Prothero's name has not been asked. I haven't finished my. The state is standing
wait
behind.
a second. Let me just finish your question. And I'll make a ruling at that point. Ask your entirety of the question.
The document in evidence, the indictment, with your name and Mr. Prothero's name on it as charged individuals, is that some sort of forged document?
Okay, if you're just joining us, I'm Lauren Cadillac. I am the owner of Cadillac Law, and I am obsessed with watching trials. I don't know why. It's sad. It's sickening. Make sure you chat. I would love to hear your opinion of this just absolute shit show out of Georgia. I'd love to hear what you have to say. So chat me up while we're here, and make sure you hit like and subscribe. But welcome to the party, y'all.
Objection, Your Honor. He has no foundation.
I'm asking him a question.
It's not.
Yeah, let him ask the question. Oh, God, I cannot stand this
His
law.
credibility is very relevant.
I sustain the objection. I'll move on.
All right. Let's go back to 2000. Or let me ask you this. When Mr. Steele asked you what you meant when you said you were asking for some slack from Detective Quinn, you said you can't recall. That was a lie.
Objection, Your Honor. Same thing. That is what he's asking.
What is her objection? I can't stand her, y'all. I cannot stand her. Okay. So he brought up Detective Quinn.
Let's go back to 2013.
Which I'm very glad because Detective Quinn was next on the stand and he came on, was it Wednesday? Hold on. Trying to think where this guy. Okay. He must have come on after Adrien Bean. No, it certainly could have been there. So this guy, Detective Quinn, I don't know where he, I cannot remember what day he came. I'm telling you, just the days are. By the way, someone put a motion in, and they were outlining how long the trial had taken, and we're gonna go. I found this Quinn stuff. This guy, I don't like him at all. Anyhow, this lawyer wrote a motion, and I don't know what the contents of the motion were, but in the motion they calculated, like, based off how long we've taken so far and how few witnesses we have, we are going to be just on the prosecution side here until October of 2027. Just for the prosecution to get their story out is going to be October of 2027. Like, oh, October of 2027? Hold on, I'm trying to calculate because my daughter was born in October of 12. She's going to be 12 this year. That means she would be 13, 14, 15 years old. And that's just to get the prosecution side out. That isn't even the defense. That's crazy. It's already been the longest trial in Georgia history. And so, like I said on Monday, we had 120 days in and only like 44 days of even trial, and 2 of those, there was nothing in front of a jury. So it's going very, very slowly. Judge Glanville is not helping, and we're going to get to that in a minute. But, I mean, it's amazing. Okay, so let me show you Thug today in this green suit. I love it. This green is beautiful. So, the prosecution calls this guy called Detective Quinn, okay? And he's the guy who's been in all of the recordings so far with Adrien Bean. And here is Quinn. Hold on. I do not like Detective Quinn. I didn't like him in the recording with Adrien Bean, and I don't like him now, and I'll show you why. Okay, he's getting sworn in. Alright, so we're on Quinn. I think this was Wednesday.
David Quinn, David Quinn.
See that? He literally talks out of the side of his mouth. Literally speaking out of the side of his mouth.
And good afternoon. How are you employed?
I'm retired.
What are you retired from?
The Atlanta Police Department.
And how long?
You see that? Where he's got the whole time he's talking out the side of his side of his mouth.
I want eyewitnesses.
I
want him.
Listen, I'm really glad I caught this. So she's asking about how he does an investigation and whatnot. Apparently, he's one of the detectives that came to this officer-involved shooting that Bean was testifying at. So she's asking him how he does an investigation. Here, he starts talking about, I want eyewitnesses. I want to know what people have to say about this, so on and so forth. I'm glad he said this, because this is definitely 100%, this is coming back in cross-examination. Trust.
To give information that could lead to some kind of inroads in closing this case. As I got older in the department, technology became a useful tool. We've always had fingerprints. You want fingerprints. DNA became a really big deal around 2002. I've watched everything change, but I always with.
Oh, he's awful. Just talking out the side of his mouth. Blah, blah, blah.
Just rough.
I mean, thousands. I mean, I can't put a number on that.
And you talked a few moments ago about building rapport. Tell the jury, why is it important to build rapport?
You don't want your interview to be adversarial. You want people to be calm and give you truthful testimony.
I'm so glad he said that, because we're about to hear an interview today where he's rather adversarial with the witness.
Testimony that you can verify later.
Mr. Stewart, you got to pose an objection, and then you got to tell me a basis. Because selling your honor doesn't let Miss Weaver know who you are. So please go ahead and objection and tell me your basis.
I have a motion. I have a motion.
All right, ladies and gentlemen of the jury, can I get you to step into your headquarters for just a second? Detective, can I get you to step outside for a minute?
That was YSL Steele, Brian Steele, by the way, who said he had a motion.
right, ladies and gentlemen, our jury has left us and our witness is off the stand. Yes, Mr. Steele, what's your motion?
Okay, here we come. He's got the sticky notes. You know it's important.
I tried
if
to
Steele
preempt
wants
it at the bench. It's exactly what I asked. And I'll wait for Ms. Weaver if the court needs it for the exact quote. But Detective Quinn just said, upon questioning the district attorney, why is it important to develop a rapport with a witness? And the answer was something to the effect of, to get truthful information. No witness can talk about veracity or truthfulness or believability of anybody. That's what I tried to say at the bench. That's the entirety of this testimony so far. I'm moving for a mistrial on Mr. Williams because this gentleman interviewed a big witness in this event. The only witness that puts Mr. Williams involved in this
Steele
event.
is asking for a
And
mistrial
now,
like every 4 minutes, and I think it's great. He should be. This is
The
amazing
information
advocacy. So obviously, judge overrules it. They continue on with this
about what happened to
side
him.
talking guy. I do not like this man.
Was he able to tell you, and don't tell me what he said, but was
He answers just like this is a character we played in mock trial.
he able
y'all.
to tell
It's
you if
awful.
money was taken from him?
Yes.
Oh, then she gets these sneaky questions. Was he able to tell you if money was taken from him? Not did he tell you money was taken from him? Not what did he say? So she's trying to circumvent hearsay by saying, was he able to tell you these things? It's very
You're
sneaky.
right, I'm asking if he was able to tell him that.
It's very sneaky, and I'm going to use it, okay? But no, it's terrible. It's great advocacy, but it's sneaky.
Not what he said.
I'm over with the objection on both bids.
It's still hearsay.
Mr. Sharp, you may answer the question, Detective.
Was he able, not what he said, but was he able to provide that information?
Yes, he was.
When you interviewed Derek Dotson, to your knowledge, did Detective A.B. Calhoun observe that interview?
Yes, he did.
With Detective Calhoun, to your knowledge, was he responsible with inventorying that money that you said was found on the ground outside of that red car?
He was.
Okay. And after you spoke with Derek Dotson, was Investigator Calhoun able to tell you how much money he inventoried?
Yes.
How much money did he inventory?
$970 cash.
And your Honor, Detective Calhoun did testify previously.
$970. How does $970 further your gang activities? Like, it's so far we've seen nothing. All right, now Brian Steele comes back up with the testimony passes. This guy is squirrely. He's talking out the side of his mouth. I don't like it. He has that very the machismo. He's from Atlanta and he doesn't even have like a southern sounding accent. I find that to be obnoxious. Okay, now here comes Brian Steele. He is lit. At one point, he was objecting to something, and then the judge called him unprepared, and he was not. And here he comes. This is a stronger man than I, because
this is the second time that this honorable court, in front of the jury, has addressed me inappropriately and wrongly. Second time. The first time, I gave this...
Second time. Like, he sounds like my mom. Like, this is the second time I told you that your room needed to be clean. Not the first. The second. The first time I gave you a pass. Steele gets lit. So let's just listen. I'll try not to interrupt him.
State discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have no. I need to make a record. Your Honor,
Mr. Steele, wait a second.
Record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little
See that
delays.
deflection? You see that deflection? Steele is talking about one thing, and then the judge completely deflects. He never denies that he made this admonishment in front of the jury. He never apologizes. He just deflects.
It's just elongate out our presentation in front of the jury.
Oh, now we're talking about the elongation of the presentation in front of the jury. Now, on day 46 of 122, now and just now we're talking about that. Cool.
That's for your benefit.
How is that
Not
for...
for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of...
And we want to thank Law and Crime for reporting this. This is fair use. We're learning here, you all.
keep this thing presented in a way that the jury can listen to it.
And the court is wrong. What
Okay,
happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect.
Okay, which call? Which call?
These calls, as you...
Okay, well then why...
Let me finish, he said.
Why aren't we taking them up beforehand?
The state just said, just now, these are the 3 additional calls that they want to
Okay,
introduce.
all right. Well, then here's your response. I'm going to give you an acceptable response.
I'm going to
Judge,
make
hold
my
on.
motion.
Huh?
I need to make my motion.
I need to
Judge?
finish my motion.
There's more to this than we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. I wouldn't have had that opportunity.
He did say that,
That's
though.
why I keep telling you this, okay? I mean, like I told you.
They said
forewarned
these are
judge,
3
a happy
brand new
judge.
calls.
All right, so had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know. I don't know what the third one they tried.
Okay,
to
well-
listen. Let me just finish. So
Let me just finish.
presuppose
Let me just
I don't know
finish
what
my
the
motion.
calls
Come
are.
on,
I don't know
Judge.
what the third call is because Ms. Hilton, who's professional, said I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at a chicken. They're discussing chicken wings. Or chicken. I understand care. But what does it do to Mr. Williams?
Mr.
Yes.
Steele, I'm not trying to personally
Yes.
insult you or hurt your feelings, okay?
It doesn't matter how Mr. Steele feels. What matters is that the jury heard the judge admonish him. And that is going to bias them against Mr. Steele and therefore against his client, and that is unconstitutional.
You are a grown professional advocate. I'm a grown professional jurist.
I am grown.
And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No,
but
that man's
Saying
life
that in
is
front of
here.
the jury is not the trial of the case.
and you
Guys, it affects him.
you're doing a fine
Everyone
job in
doesn't-
representing him.
Well,
but you know what?
But you didn't tell the jury that.
That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me because I have given you all this administrative time, all these breaks to go ahead and do this.
But he also has, every time they've come to him, he said, I'll make a ruling on this later. I'll make
All
a
we
ruling
got
on
on the
this
sta-
later. So if the judge would make a ruling when they actually came to him about these issues, they wouldn't be running into these time blocks. I don't know how this judge is now passing the time issues off onto the defense. It does not make any
And
sense.
for Mr. Bean was, I don't recall,
I
I
love
don't
this
recall,
guy.
I don't recall. They are
Max,
trying to
Max, or whatever his name is.
rehabilitate.
He's
They
a
have
good
a
lawyer.
prior statement made by Mr. Bean, and they're saying prior to this prior statement, there's a motive for recent fabrication, so we want to go behind that. But I can't find any case law that suggests that you can rehabilitate a prior statement that was not testified to on the stand. So on the stand, we got nothing from Mr. Bean. So I don't believe that there's anything to rehabilitate under the prior consistent.
Okay, so the prosecution then tries to enter some prior consistent statement of Mr. Bean, and Sharp, or whatever his last name is saying that that shouldn't be the case. They shouldn't be able to
Statement,
rehabilitate.
statute, because all we got on the stand, I think we
Because he didn't actually testify. All he said is, I don't know, I don't remember, I don't remember. Okay, so this is Wednesday. As we get to the end of Wednesday,
Ask him when he comes in. In fact, can you have our detective
we do
Quinn
some
come in,
scheduling.
please?
So they have Quinn come back in, and they're talking to Quinn about his schedule. Okay, then they have the jury come back in and talking to them about scheduling. Now, mind you, so far this week we've seen maybe about 4 hours of testimony, 2 hours on Monday, 4, we're at 6. We're maybe at 7, 8 hours of testimony Wednesday afternoon, all right? Now we're going to bring the jury back in. Now, mind you, the judge was just complaining about all the delays and how long it takes and blah, blah, blah.
Say the 1st through the 5th. That is your administrative pause.
This is taking too long. I need to move this along. This is being too long. And then immediately turns to the jury, says, we're not working on Thursday. You have the 1st to the 5th off as an administrative pause, which I understand. I think that's their spring break. Okay, but we've already had Thanksgiving break. We've had Christmas break. We just had a break last week.
By consensus. Do not ask me for any more pauses after that, okay? Use the time that I give you to go ahead and take care of what you need to take care of. And when you come back, and we commence back on the 8th,
On the 8th, y'all.
no, because you're not here next week.
Yes.
Oh, hold on, did I skip a week?
Yes.
Yes, he skipped it. Say he doesn't even know what week it is.
You are, yeah, well, okay. Yeah, we're together all next. We're together all next week. The week of the 1st of April, you'll be out.
All right. That's it. I mean, he gives them the whole,
You'll be on
and
a
that's
pause,
like their
okay?
spring break, so it makes sense that they're not gonna, meet together. He talks to Quinn, and Quinn has some scheduling issues and such, so there's probably gonna be some other witness in between then. The judge then proceeds to take Thursday off as an administrative day, so yesterday, and then says we'll come back on Friday at 12:30 p.m. At one point, the judge threatens counsel and it's like, do we need to start an hour earlier to hear motions? Yes, we do. We need to start at least an hour earlier so you can hear our motions before we see the jury. Hello? How is that a threat? I mean, it's wild. This man is essentially blaming the defense for the delays and then causing further delays. Incredible. Okay, so today there will be another witness. I don't think it'll be talking out the side of his mouth, Detective Quinn. I think it's someone else, but we'll see. There will be someone this afternoon, and then we'll resume again on Monday, probably at noon. Who knows, if they decide to even work on Monday. I'm telling you, y'all. I will say, like, though there are some horrible judges in Texas and where I practice, there are some judges that aren't that great. All of our judges, at least in the Dallas area, are moving things along. It's not going to be like this. This is just a train wreck. Like, this is incredible. So we're thinking that every Friday until 2027, you're going to see my beautiful face recapping this. And that's just for the prosecution side. There's no jury in the world. There's no set of people in the world who can listen to 3 years of evidence, period. Like, you can't, it's not even doable. It's ridiculous. It's too much of an ask of our government on anyone ever. So, anyhow, this trial is such a mess. You know, my son sent a text in the family chat and said, "Hey, gang." And I said, "Don't do that, because if we go to Georgia, we're going to be prosecuted on RICO." That's how stupid Georgia looks right now. All right, y'all. Thanks for joining me. I really appreciate it. I got to log off. I got to get some work done before they start their second round of testimony, or their testimony this afternoon, first round of testimony for Friday. Ridiculous. I really appreciate you joining me. Make sure you hit like and subscribe.